So I welcome you all to lecture number 8 in Sale of Goods Act 1930. This is a part of CA Foundation lecture series sponsored by Sri Chandra Youngson. I am your mentor Shekhar Gehlot. So in this series of Sale of Goods Act, we are discussing Sale of Goods Act in parts, and this forms a crucial part of syllabus for the CA aspirants. Those people who want to become a CA, they have to clear a CA foundational course, and this is one of those important acts which is very much asked in the CA foundation course by the exam conducted through ICAI annually twice. Okay, so now in this chapter we'll commence it with the circumstances under which the right to disposal may be reserved. Okay, now what do we understand by right to disposal may be reserved? That means, like we have discussed in the previous chapters, when the right to disposal is reserved, it is a conditional sale. Okay, which means that sale shall not become operative or will not come into picture till the time right to disposal is also sold. Okay, when we are committing a sale, when we are entering into a sale, the transfer of property in goods passes ultimately to the buyer. Okay, where the transfer in property ultimately transfers to the buyer, it means now buyer has a right to dispose of the property as per his on wish. Like we discussed the example of a car, now buyer may use the car, or he may resell it to someone, or he may give it on rent, or he may make some modifications to the car, or he may just simply scrap the car. Okay, he may remove the engine of the car, remove the roof of the car, metal part of the car, maybe separate tires and seats and fabrics, all other, and he can divide the car into smaller parts and sell it off. He can do whatever he wish to do with the car. Okay, but in this situation we are discussing that when the right to disposal is reserved by the seller, that means you cannot dispose of the property, or you cannot deal with the property in the way you wish. Okay, there is a rider upon you. Okay, that means you can have a delivery of the product, but you cannot use it as per your liking till the time that condition which is imposed by the seller is not complied on with you, is not complied by with you. Now some may argue that in what conditions or what are those circumstances in which seller may reserve his right to dispose. Okay, reserve his right to disposal of the property. Now let us discuss those circumstances which may trigger such an event in which a seller has reserved his right to dispose of the property. Now, in the following circumstances, seller is presumed. Now, it is a case we are discussing here that this is not when it is expressly declared or expressly put into the part of the contract. Okay, but it is just like we had presumed or implied conditions or implied warranties. We have certain circumstances in which the law shall presume that seller indeed had reserved his right to disposal, or the sale was actually a conditional sale, and sale will not come into picture till the time that condition has been fulfilled by the buyer. These are those circumstances in which it shall be presumed. Meanwhile, you people spare a moment and read it, and then we'll get back and I'll discuss these clauses with you. Take 2 minutes and read it. So now let's read it. The clause 1 says, if the goods are shipped, okay, or delivered to a railway administration for carriage, okay, they are shipped or delivered to a railway administration for carriage, and by the bill of lading or railway receipt, okay, by the bill of lading or railway receipt, as the case may be, the goods are deliverable to the order of seller or his agent, then the seller will be prima facie deemed to have reserved the right of disposal. Now this simply says that whenever a seller is selling his goods and he has put his goods in the mode of transport. Now, the mode of transport may be anything. Okay, it may be by the plane, it may be by train, it may be by road. Okay, trucks also may carry a delivery. So now, if upon the delivery, the bill of lading or the receipt of delivery suggests that delivery can be accepted. Okay, when goods are loaded from some place, they'll definitely travel to some other place. And upon travel to that particular place, if the delivery can be accepted only by the seller or his agent, then in these conditions, though he may not have said anything like this, or there is no contract to such stipulation, but it will be presumed that seller has reserved his right to dispose of the property and the property and goods have not passed to the buyer. So in this time, if meanwhile in the journey, when they are in the mode of transmission, some misfortune happens with the goods are destroyed or goods are damaged in such a condition that they do not now correspond to the description, then such loss shall be borne alone by the seller. But if he has given a bill of lading which says that delivery will be accepted by the buyer or his agent, then if something happens, then the risk runs with the property to the buyer because the owner will assume the risk. Okay, now ownership is still with the seller, so the risk will remain with the seller alone. Where the seller draws a bill on the buyer for the price and sends him the bill of exchange together with the bill of lading, as the case may be, the railway receipt to secure acceptance or payment thereof. The buyer must return the bill of lading if he does not accept the bill. And if he wrongfully retains the bill of lading or the railway receipt, the property in goods does not pass him. Okay. Now there is a situation in which now he has drawn a bill of lading in the favor of buyer. Okay, now he has admitted that delivery will be taken by buyer or his agent. So now when he wants to, so how will he send the bill of lading to the buyer? Definitely he'll courier it or he'll fax it or he'll email it. Okay, then the buyer can take it. Okay, he can take the printout or he can accept the courier. So now along with the bill of lading, he has attached a bill of payment as well. Okay, along with the bill of lading, he has attached a payment or invoice of the product and it mentions that you must pay the price before accepting the delivery. Okay, then in this case, if the buyer refuses to pay, if he does not pay and he accepts only the delivery, in that case, it would be presumed that seller had reserved his right to disposal of the property and property had not validly reached to the buyer, and if buyer is subsequently selling the property, then seller can claim it back from the subsequent purchaser because the ownership had not transferred to the buyer as he had not made the payment. In this case as well, the risk will remain with the seller only. It should be noted that Section 25 deals with conditional appropriation as distinguished from unconditional appropriation dealt with under Section 23.2. Section 23.2 dealt with unconditional appropriation. Okay, when there is an unconditional appropriation, therefore, in that case, the seller has not reserved the right to disposal, but here it is a conditional appropriation. Here, seller has reserved his right to disposal. So that means there is no sale yet. Now, risk prima facie passes with the property. This is section 26, which lays down a rule which says that risk passes with the property. Okay. Risk passes with the property. It simply means that whoever person is the owner of the property at a particular point of time will bear the risk or will suffer the damage in case there is some damage to the property or there is some risk happening with the property. So now the risk passes with the property, that means risk passes with the ownership. So whoever was the owner at the time of damage happening to the goods, he shall bear that risk. The financial implications shall be upon that particular person only. Okay. According to section 26, unless otherwise agreed, the goods remain at the seller's risk until the property therein is transferred to the buyer. Now, this is very clear that unless otherwise agreed, definitely goods remain at the seller's risk until the property therein is transferred to the buyer. Definitely till the time sale has not taken place. Finally, the risk shall remain with the seller. But when now, this is the crux. But when the property therein is transferred to the buyer, the goods are at the buyer's risk whether delivery has been made or not. Now, whether delivery has been made or not, now the risk will lie with the buyer, and we have discussed it sufficiently in the previous chapters as well. Just for simple example illustration, I'll again tell you that A buys four chairs from the B. Okay, and the chairs are kept in the B's go down. Okay, and A has stated to the B that you can take them whenever you want to, and A says, okay, I'll take them as per my choice. Now there is a fire in the go down, so those four chairs which have now burnt out, the risk will pass to the A, that is a buyer. Okay, because he left his property at somebody else's go down. Now the chairs do not belong to that go down, they belong to that go down earlier. Now that go down is a foreign go down for that chairs. The chairs should have been with the A, but he kept them with the B out of his own choice. Now, if something happens, the delivery has not taken place. Chairs are still where they used to be. But now the property in the goods, property in chairs have passed to A. So now when there is a fire, the risk will be suffered by A, that is the buyer. Provided that where the delivery has been delayed through the fault of either buyer or seller, the goods are at risk of the party in fault as regards any loss which might not have accrued but for such fault. Now, suppose property has passed, okay, property in goods have passed to buyer, okay, and buyer tells, now buyer has bought two cars from a seller. Now the seller says that I will deliver the cars on 25th of October. Okay. So now before 25th of October, the cars are responsibility of seller because that is under his care now. Okay. It is not that buyer has left the cars with the seller. The buyer has himself assumed that he will bring the car and he will deliver them by 25th of October. Now, the property in the goods definitely have passed to the buyer, but the risk will still remain with the seller because they are in the care and custody of the seller, and seller has himself assumed that care. And if something happens due to the fault of seller, Okay, something happens due to the fault of seller, the seller will bear the risk. but but if there is no fault of the seller, if something happens due to no fault of the seller and no fault of the buyer as well, then the risk shall lie with the buyer. Situation 1 is fault of seller. If damage happens due to the fault of seller, then in that case seller is liable for that risk. Now, second situation is seller is not at fault and the property and goods are passed to the buyer and still there is some damage despite taking all cares by seller. In such case, the risk shall remain with the buyer when seller is not at fault. Provided also that nothing in this section shall affect the duties or liabilities of either seller or buyer as bailey of goods of the other party. Further, it shall not affect the duties of a bailey. Bailey is a person to whom bailey Okay, like a car may be delivered to a mechanic for repairing or a musical instrument, say a piano, a costly piano or violin was delivered to a friend for using or for playing or for learning or some special event. In those cases, though Bailey is taking money for doing that service or he is taking for free, whatever may be the nature, Bailey is always expected from the law to take reasonable care of the products. Okay, Bailey is expected to take reasonable care of the products. Like suppose the friend has taken the piano, he cannot leave the piano on the roof for 2 3 days, and when there is a rain, there is a damage to the piano, and now he cannot say to the friend that because I do not own the piano, you own the piano and the risk passes with the property, so whatever damage is with the piano you shall bear it. No. If something happens to the property due to the fault of bailey, then the bailey shall be liable. But if there is no fault of bailey, then owner will be liable. Okay, similar is the case. Just like we discussed seller, there may be two situations. So if bailey, like a car mechanic, now he is taking a test drive of the car but he is driving rashly and he hits a wall, so whatever is the damage to the wall as well as the car will be liable, this mechanic will be liable to bear it. Okay, but if there is some fire in the godown, and this is not at the fault of the workshop, this is not at the fault of the Bailey. There is some fire in the nearby go down, and it catch the workshop of the Bailey as well, or there is some earthquake or some other calamity which Bailey could not have controlled or taken care of. In that case, the damage, whatever happens, will be with the buyer only. Okay, so Bailey is required to take care of the goods belonging to someone else as his own. Okay. Okay, now what standard of care and caution or protection is required from Bailey? The law says Bailey shall take care of the piano as he would take care of his own piano. Okay, or the mechanic will take such care of the car which is up for repair as he would take of his own car. Okay, if he does not take the care of the car in such a manner that he takes care of his own car, then he shall be at fault. Okay, this is the standard of the care. The general rule is unless otherwise agreed, the goods remain at the seller's risk until the property therein is transferred to the buyer. But when the property therein is transferred to the buyer, the goods are at buyer's risk whether delivery has been made or not. This is the general rule. This is the general rule that once property and goods is transferred to the buyer will be the risk will be with the buyer whether or not he has taken the delivery. But this section 26 is an exception to the general rule. Now, what is this exception to the general rule? It says that risk follows ownership. This is the general rule. It provides that where delivery of goods has been delayed through the fault of either buyer or seller, the goods are at risk of the party in fault as regards any loss which might not have occurred but for such fault. Okay, if the delivery is delayed due to fault of seller or buyer, okay, then the damage happening will lie with the person who is responsible for this fault. Thus, in ordinary circumstance, risk is borne by the buyer only when the property and goods passes over to him. Okay, thus ordinarily risk will be borne by the buyer. However, the parties may by special agreement stipulate that risk will pass some time after or only before property has passed. Okay. However, there may be some tailor-made agreements in which people may agree that risk shall begin to pass, risk shall pass only on that particular event or only on that particular date, otherwise not. Risk prima facie passes with ownership. Okay. Read it in a moment and we'll discuss it. It says That owner of goods must bear the loss or damage of goods unless otherwise is agreed. Otherwise, if it is agreed that seller will bear the loss or some other party, third party, like the case of insurance, some other party like insurance contract. Okay, if there is a contract which says third party, that is an insuring party, shall suffer the loss. Okay, then owner will suffer. Generally, owner will suffer the loss. Under Section 26 of the Sale of Goods Act, unless otherwise agreed, the goods remain at seller's risk until property therein has passed to the buyer. After that event, they are at buyer's risk whether delivery has been made or not. Okay, we have discussed this. Now you read this example and we'll discuss the example. A bids for an antique painting at the sale by auction. Now this is a sale by auction for an antique painting. Now A is the bidder. After the bid, when the auctioneer struck his hammer to signify acceptance of the bid, he hit the antique which gets damaged. Now he suddenly, because in the sale of auction you must have seen in the movies, sale is concluded by fall of a hammer. Okay. So now when he is hitting the hammer, he accidentally hits the antique which gets damaged. The loss will be borne by the seller. Okay, the loss will be borne by the seller because the ownership of goods has not yet passed from seller to buyer. Okay, because the property has not yet passed from the seller to buyer, because before fall of the hammer has struck the painting. Okay, before the fall of the hammer has struck the painting. The aforesaid rule is, however, subject to two qualifications. Two qualification means two exceptions. If the delivery has been delayed by the fault of the seller or the buyer, the goods shall be at the risk of the party in default as regard loss which might not have arisen but for default. If there is some delay on part of any person, then there is some risk. Now, if the buyer delays the delivery of the goods and the goods are damaged by the flood, buyer is liable. Okay, because had he have taken the delivery at the right time, he could have averted the flood damage to his goods. But if the delivery is delayed by the seller, then the seller is at the risk. The duties and liabilities of the seller or the buyer as bailee of the goods for the other party remain unaffected even when the risk has passed generally. But it does not mean that seller or buyer they will forfeit their duties which are expected from the law. Okay, seller has to take care of the goods. Okay, now suppose there is a flood, buyer has delayed the delivery and there is a flood, but now initially buyer is the one who has delayed the delivery, he is at the fault. Okay, and the flood damages the goods. Now the buyer must pay the risk. But if it is the case where one day prior warning for the flood was issued by the department and the seller had enough time to remove the goods and relocate them at some other position, though the delay is by the part of the buyer, but seller has now here forfeited his duties of a regular bailee and he failed in removing the goods from a dangerous area. And now when the flood hits, now in this case seller will be liable, not the buyer, because seller has failed to take the duties which is expected from a regular bailee. Now seller is in the footsteps of bailee here, as because he is not the owner, he is only having the custody. Bailee only has the custody, bailee is never the owner. Example: A contracted to sell 100 bales of cotton to B to be delivered in February. B took the delivery of the part of the cotton but made a default in accepting the remaining bales. Consequently, the cotton becomes unfit for use. The loss will have to be borne by the buyer because now buyer delayed the delivery, and ultimately by the lapse of time, due to the perishable nature, cotton has become unusable. Now it is buyer's fault. Okay. It should, however, be remembered that the general rule shall not affect the duties or liabilities of either seller or buyer as a bailee of goods, even when the risk has passed. Okay, now in this case, if seller could have stopped the bales from perishing, if he could have used some chemical or some disinfectant which he is using applying on other bales as well, but not on the bales of the buyer, then he shall be liable. Then the seller shall be liable. As noted above, the risk, that is, the liability to bear the loss in case property is destroyed, damaged, or deteriorated, passes with the ownership. The parties may, however, agree to the contrary, like in the case of an insurance contract. For instance, the party may agree the risk will pass sometime after or before the property has passed from seller to buyer. Okay, they may customize it. Now we'll go to transfer of title, that is within section 27 and 30. Give a quick reading to section 27 and then we will discuss it. Sale by person, not the owner. Transfer of title. We are discussing transfer of title. Transfer of title means transfer of ownership. Title is ownership. Okay, who has the title over the goods? The owner has the title over the goods. Okay. Now, how can transfer of title take place? Let us discuss. Sale by person, not the owner. Can someone who is not the owner transfer the title of ownership? The question is, now this is the question. Can someone who is not the owner still sell the goods just like as an owner would do and pass the valid title? Let us see. Subject to the provisions of the Act and for any other law for the time being in force, where goods are sold by a person who is not the owner thereof and who does not sell them under the authority, who is not the owner plus who does not sell them under the authority or with the goods or with the consent of the owner. Now, someone is selling it, but he is neither the owner nor he has the authority nor he has the consent from the owner to do so. The buyer acquires no better title to the goods than the seller had, unless the owner of the goods is sold by his conduct precluded from denying the seller's authority. Unless the owner is precluded from his conduct, the buyer will not get a good title. Okay. The title of the buyer in such sale shall be defective, and the original owner could claim the goods back from such buyer because he became owner without authority. Okay, the sale was without the authority of the original owner, and only original owner has the right to dispose of the property. Okay, unless the owner of the goods is by his conduct precluded from denying the seller's authority to sell. Now, unless his conduct is such, okay, his conduct is such, conduct may be like okay. Now, unless I have from my conduct conducted the sale. I have conducted the sale from my conduct. Like this example, I own a bike, but in my presence, my brother, my brother sells the bike to C and claims that he is the original owner. My brother claims to be the original owner, but the original owner is me. But I am also present there, and I do not interfere. I do not refute, and he accepts the payment and he transfers the property. In this case, I am precluded from controverting the sale later on. I am stopped. I cannot go to the court and say that sale is invalid because I am the owner. Because from my conduct, by being present there and not refuting the sale, I have now accepted the sale. That means the sale has taken place under my authority or my consent. In such a case, he will get a valid transfer of bike in his name. Provided that where a mercantile agent is with the consent of the owner in possession of goods or of a document to title to goods, any sale made by him when acting in the ordinary course of business of a mercantile agent shall be as valid as if he were expressly authorized by the owner of goods to make the same. Provided that buyer acts in good faith and has not at the time of contract of sale noticed that seller has no authority to sell. Provided that a mercantile agent is making a sale. Okay, when the mercantile agent, acting in his usual course of business, makes a sale, then such sale shall be a valid sale. Let us discuss the example. Who can be a mercantile agent? Let us discuss the example. Muthoot Finance. That's the case of Muthoot Finance. I pledge my gold with Muthoot Finance for 1 year, and if I do not repay, Muthoot shall sell it. Okay, now in this case, if I do not pay, if I fail to pay and Muthoot has sold it, now the buyer, whoever will buy from the Muthoot Finance, will get a good title over it. Okay, he will get a good title over it, and I cannot challenge the sale. Or suppose, okay, now I purchased a truck full of bananas from a dealer, and I did not take the delivery. I told him that I'll take the delivery later on, and I do not show up for next 1 to 2 days. And bananas, by their nature, are perishable. They quickly perish out, so they're at verge of perishing. And the dealer made the sale of bananas, those bananas which he has already sold to me to someone else. Okay, now I had not instructed him to sell, but he has now sold in order to preserve the property of the goods. Now, in this case, such sale shall be valid, and the new buyer will have a good title of the banana. He'll have as good title as I had over it. In general, the seller only in general the seller sells only such goods of which he is the absolute owner. But sometimes the person may sell goods of which he is not the owner. Then the question arises as to what is the position of the buyer who has bought the goods by paying price. The general rule regarding the transfer of title is that seller cannot transfer to the buyer of the goods a better title than he himself has. Okay, if the seller is not the owner of the goods, then the buyer also will not become the owner. Okay, if the seller is not the owner, the buyer will not definitely become the owner. The seller will sell whatever right he has. If he has no right, he cannot sell any right at all. The title of buyer shall be same as that of the seller. This rule is expressed in the Latin maxim nemo dat quod non habet. Nemo dat quod non habet, which means no one can give what he has not got. No one can give what he does not have. Okay. So a seller with defective title cannot pass on a better title. He will definitely pass on a defective title only. Now these are examples. If A sells some stolen goods to B, who buys them in good faith, B will get no title to that, and the true owner has a right to get back his goods from B because A had stolen those goods, and after stealing he gets no title at all. P. The hirer of vehicle under a hire purchase agreement sells them to Q. Q, a bona fide purchaser, does not acquire the ownership in the vehicle. At the most, he acquires the same right as that of the hirer. Okay, in such case, because he is an hire purchaser, he will not get any title over the goods at all. Because a hire purchaser will get no authority to sell the goods unless he has made the purchase, he has finalized the purchase. If this rule is enforced rigidly, then the innocent buyers may be put to loss in many cases. Therefore, to protect the interest of innocent buyers, a number of exceptions have been provided to this rule. Okay, because this is such a rule in which innocent buyers may be lured in, may be cheated by normal people. So, there are certain exceptions to this rule. Let us now discuss these exceptions. Okay, one by one. The first exception is sale by a mercantile agent, which we have discussed. A sale made by a mercantile agent for the goods of the document of title, for the document of title to goods would pass a good title to the buyer in the following circumstances. Namely, okay, it is not that whenever a mercantile agent is making a sale which is not authorized to make, that every time sale will be a valid sale. Okay, it will be a valid sale only upon the fulfillment of following conditions. Let us see the conditions. If he was in possession of the goods or documents with the consent of the owner. Okay, if he had the possession of those goods by the consent of the owner. If the sale was made by him when acting in the ordinary course of business as mercantile agent. Okay, when he is acting as a mercantile agent, he made the sale. If the buyer had acted in good faith and has at the time of contract of sale no notice of fact that seller had no authority to sell. Okay, if the buyer acts in a good manner, okay, good faith he acted, he had a good faith, he had a faith on the mercantile agent that whatever this gentleman is selling me belongs to him, and he did not know that he is not the original owner, then his right is protected and he gets a good title because mercantile agent has a right to sell, he has an authority from the owner. Sale by one of the joint owners. Okay, if one of the several joint owners of goods has the sole possession of them by permission of co-owners. The property in goods is transferred to any person who buys them from any such joint owner in good faith and has not at the time of contract the sale notice that seller has an authority to sell. Okay. So now, when joint owners jointly give consent to another joint owner, there are five owners. They give authority to fifth one that you do one thing, you deal with the property the whatever way you like, you stay in it, you rent it out, or you sell it out. Okay, sorry, property is not movable property. So take the example of a car. You do whatever with the car. So when he sells that car, okay, then it shall be presumed that he has made a valid sale if at the time of making the sale the buyer had no notice. He did not know that he is not the actual owner of the goods. Let's do an example. A, B, and C are the three brothers and joint owners of a TV and VCR. And with the consent of B and C, the VCR was kept in possession of A. A sells the TV and VCR to P, who buys it in good faith and without notice that A had no authority to sell. P gets a good title to VCR. Okay, even despite if other owners had not given the authority to the to sell to other owner, okay, other co-owner. Then also if co-owner is making a sale and the buyer has no occasion to know that the authority is defective, then he shall get a good title because the sale is being made by a co-owner. So he has no reason to believe why a co-owner cannot sell his own property. He believes that other owners must have given the confirmation of sale to him. Sale by a person in possession under a voidable contract. Now we discuss a voidable contract is a contract which has not become void but may be treated as void. Okay. Okay. A buyer would acquire a good title. Why? Because voidable contracts can be declared void on the only upon the insistence of a party which has got affected due to the misconduct of a other party. So, upon such declaration, the contract will be deemed void. But till the time the other party has not exercised his or her right to get the contract declared void, the contract will remain a valid contract. Okay, because it's a voidable contract, it has the characteristics of both a valid contract as well as a void contract. Okay. A buyer would acquire a good title to the goods sold to him by a seller who had obtained the possession of goods under a contract voidable on the grounds of coercion, fraud, misrepresentation, or undue influence, provided that contract had not been rescinded until the time of sale. That means at the time of sale, the contract had not been set off by the original owner. X fraudulently obtains a diamond ring from Y. This contract is voidable at the option of Y. But before the contract could be terminated, X sells the ring to Z, an innocent purchaser. Z gets the good title and Y cannot recover the good ring from Z even if the contract is subsequently set aside. If the contract is subsequently set aside, what can Y do? Y can only take the money from the X. He cannot take back the ring from Z. Okay, but if before the sale he had declared the contract as void and thereafter Z purchases it, okay, then Z will have to return the ring to the Y because his right is now defective. Imo that kyod non habet. No one can deliver what he does not have. So it would be assumed that X did not have the ring. So when he delivered the ring to Z, Z does not get any good title over the ring. Sale by one who has already sold the goods but continues in possession thereof. Okay. Now there may be a situation in which a seller is has sold the product but he still continues in the possession of the goods, like we discussed the case of a banana seller earlier in the slides. Okay. If a person has sold goods but continues to be in possession of them or of the documents of title to them, he may sell them to a third person, and if such person obtains the delivery thereof in the good faith and in good faith plus there has to be two conditions. Good faith first one, and without notice of the previous sale. Okay, without notice of the previous sale, he will have good title to them, although the property and goods had passed to the first buyer earlier. A pledge or disposition of goods or documents of title by seller in possession are equally valid. Okay, so when seller has the custody of the goods, he can resell them. Okay, he can resell them to another buyer, and the buyer would get a good title. Okay, because buyer does not have the notice of previous sale, plus he is acting in a good faith. So he goes to buy something with the seller. He assumes that seller has the authority to sell those goods. He does not know that seller has already sold those products. So whatever right he will get a good title over it as equal to the earlier purchaser. During ICL matches, okay, ICL matches or say IPL matches, P buys a TV set from R. R agrees to deliver the same to P after some days. In meanwhile, R sells the same to S at a higher price. Who buys in good faith and without knowledge about the previous sale? S gets a good title here. Okay, S will get a good title here because S or any other person usually will not have any occasion to know that seller is reselling the product. They always believe that seller is selling the product as a fresh sale. Sale by buyer obtaining possession before the property and goods have vested in him. Okay, sale by a buyer who has obtained the possession before the property and goods have vested in him. Okay, sale by a buyer who has taken the delivery of goods but yet he has not become the owner. In such a case, also, the sale by such buyer shall be a valid sale, where a buyer with the consent of seller obtains
It's
possession
three
of the
o'clock.
goods before the property in them has passed to him. Okay, he may sell, pledge, or otherwise dispose of the goods to a third person, and if such person obtains delivery of goods in good faith and without notice of the lien or other right of the original seller in respect of goods, he would get a good title. Okay, he would get a good title if he does not have a knowledge that this sale is a defective sale. Okay, the buyer has no right to sell because buyer does not have any ownership as of yet. He only has a possession. However, a person in possession of goods under a hire purchase agreement which gives him only an option to buy is not covered within such section unless it amounts to sale. Okay, because hire purchase agreement is not a sale agreement, it's only a hire purchase agreement. So when he does it, then his sale is not protected by this clause because he has no authority at all. He is not a buyer. We cannot call him a buyer. This section applies only on a buyer who has got the possession but not made the payment. A took a car from B on this condition that A would pay a monthly installment of 5,000 rupees as higher charges with an option to purchase it by payment of 1 lakh rupees in 24 installments. After the payment of few installments, A sold the car to C. B can recover the car from C since A had neither bought the car nor had agreed to buy the car. He had only an option to buy the car. He only had an option to buy the car, but he had not exercised that option. So we cannot call him a buyer. And this section talks about sale by a buyer. Effect of estoppel. Okay, where the owner is stopped by the conduct from denying the seller's authority to sell, the transfer will get a good title against the true owner. But before a good title by estoppel can be made, it must be shown that true owner had actively suffered or held out the other person in question as a true owner or as a person authorized to sell the goods, like we discussed, where my brother sells the bike, impersonating himself as the owner, and I am present there, but I do not refute it. In that case, I will be stopped. Okay, I will be prohibited from refuting the sale later on. A is said to be a buyer. B is a buyer. In presence of C, C is the owner. That he, A is the owner of the horse, but C remained silent though the horse belonged to him. B bought the horse from A. Here, the buyer will get a good title of the horse, even though the seller A had no title to the horse. In this case, C, by his own conduct, is prevented from denying A's authority to sell the horse. Okay, because he has acted in such a manner that an innocent person has purchased the horse. Now C cannot take a U-turn and say the sale is not valid. Sale by an unpaid seller. Okay, now a sale has made between a seller and a buyer, but the property is still with the seller and buyer has not yet made the payment as well. Okay, in such case where an unpaid seller, he is an unpaid seller because he is a seller, but he has not received the money and even goods are with him. Okay, but the property and goods have transferred to the buyer, but seller still has the custody and he has even not received the payment. In such a case where an unpaid seller who had exercised his right to lien or stoppage in transit resells the good, the buyer acquires a good title to the goods as against the original owner. What is this right to lien or stoppage in transit? We will discuss in the coming chapter. Okay, but briefly, it means if the buyer has not received the payment, he can exercise a right to keep the custody of the goods which are not yet delivered and he can even resell them. Okay. Sale under the provisions of other act. Sale by an official receiver or liquidator of the company will give the purchaser a valid title. Okay. Sale under the provision of other act, like in the company law, we when a company is going under a liquidation, court appoints a receiver. Okay, court appoints a receiver. Receiver is the one now. He has the authority to sell the assets of the company or a firm which is under liquidation. So now when an official receiver or liquidator has been appointed by the court to look into the affairs of the company, and when he makes the sale of such items to the buyer, then buyer will get a original title just like of a original buyer buying from an original seller. Purchase of goods from a finder of goods will get a valid title under circumstances. Okay, purchase of goods from a finder of goods. Now someone has found some goods. Okay, someone found a diamond ring and he has made all the attempts to relocate the true owner, but he cannot find out a true owner. Then in that case, ultimately property will become to the finder of goods because the one who has found them has a better title than anyone else. Okay, he has a better title than all people in the world other than the owner. Okay, so when the owner is not relocated or owner has died or owner is not available, then in that case, purchaser of goods can sell them, and when he sells them, the purchaser will get a good title. A seller by pawning can convey a good title to the buyer. Pawning means one who pawns it, just like Muthoot Finance is a pawning. Pawning means there's a pawn shop. Pawn shop means people put their goods and take money and return money, take goods back. If they could not pay money back, the pawn shop owner, who's known as pawning, can sell the goods. Sell the goods. Okay, so he can convey a good title to the buyer. So today this is enough for today's lecture. We'll discuss in the next lectures about other aspects of the sale, like performance of the contract of sale.